The suspects, of course, in this murder case are currently serving multiple cases for other crimes in court. So when it came to the issue of bail, many of them did not want to apply for bail because they are already being incarcerated or are awaiting trial for several other matters. So here is the Criminal Procedure Act, the circumstances in which criminal proceedings may take place in the absence of the accused. Let's speak to Bruce Hendricks, who is with Hendricks Harmser Attorneys. Bruce, good evening, and thank you so much for your time tonight. Before I get into how today's proceedings unfolded, I'm keen to know just your general impressions of how the day unfolded, especially in court.
Well, it's very strange that accused wouldn't want to appear in the dock, especially people that has been in the criminal justice system and sentenced, as they would know how proceedings would work. And they would know that one has to go through the proceedings where you appear, you are appointed a legal representative, and the matter is postponed for a copy of the docket, and you consult, and then proceed to trial. And at trial stage, then you present your version or why you say that you, in layman's terms, not guilty or innocent.
So were you surprised that the accused from the get-go refused, as we've heard from Ziyanda, to get into the dock? They refused any form of legal representation and vehemently denied any connection to this case?
Well, I am surprised because, look, if they are sentenced, or if it's not the first time they would appear in court, and it's obvious that they would know how criminal proceedings work and how it is conducted. And taken that some of the accused are sentenced, you would assume that they've been to a trial through criminal proceedings in which they know how the criminal justice system would work. So yes, it is extremely confusing as to why they would not enter the dock and either or accept legal representation that would assist him in presenting their alibi or whatever exculpatory evidence they would have in the matter.
Bruce, people talk about criminals who get up to all sorts of antics to avoid having to answer to the law. Have you seen antics of this nature before, and how often do you see them in your proceedings?
Well, I'm a criminal lawyer, and it's what we do every day in court. And yes, sometimes you do see it, but it's rather strange and bizarre, as you would want to think that the accused would want to hear what's the allegations, find out what's the evidence, who's the witnesses, and what they are saying against them. So it is bizarre, but it does happen in everyday practice where people for some or other reason do not want to appear.
The accused seem to be pointing to a greater conspiracy here that is at play on the side of the police and the National Prosecuting Authority. What would they need to do between now and the 27th of November, when they're expected back in court, to avoid that appearance and also to discredit whatever charges may be brought against them?
Well, it would always be wise in cases like this where it's extremely serious matters or charges that the accused face, that they appoint legal representation to represent them. And in a case like this, you would normally obtain a copy of the case docket, and taken into account that this matter is 6 years old, the investigation, the matter should be completed. So I would advise, if I was in their shoes, I would obtain legal representation and study the case and then present the facts or evidence or my side of the story properly before court of law, in which a presiding officer can then adjudicate on it and then a decision be made in respect of guilt or innocence.
Sure. There's been intent that was set out today to move this case to a higher court. In the interim, what does Magistrate Havenga do if these suspects continue to say that they don't want legal representation and will represent themselves? Does that jeopardize their case at all?
Well, a presiding officer like Mr. Havenga did, he was right in indicating to them that it's advisable to take legal representation. However, one cannot force that upon an accused. If they decide to represent themselves, then that is their choice. Our Constitution provides for everyone has the right to a fair trial, which includes the right to legal representation. And if one chooses to waive that right, that is entirely your own choice.
And when it comes to the actual strength then of the state's case, there seem to be some fundamentals around this case. They still need to get cell phone data of, the whereabouts of the accused before, during, and after the killing of Senzo Meyiwa. And that information like that could be critical. They're still waiting DNA results, from some of the accused versus whatever it is that they may have found that was linked to the scene. Evidence like that is crucial. Do you think that without it, the state will still be able to bring a solid enough case that can have all 5 men that were in court today convicted of the crimes that are being put against them?
Well, it would be foolish for me to comment on the strength or the weakness of the state's case, as I was not privileged to the docket content or what evidence that they have. But if you are represented in a case like this, and I mean after 6 years, a legal representative would have raised the issue as to why this evidence have not been obtained after 6 years, as it's crucial evidence to the case. However, one should request the docket then and ask these questions. And obviously, if the accused appear before court, they have a right to challenge the evidence and the statements that were made, or what is available up to now. But if they're not appearing, then it's fairly difficult for them to even know what is the evidence against them.
Lawyer Bruce Hendricks, thank you so much for your time. We'll leave it there for now.